Hello and welcome to The View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayor Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 184. Hope everyone's been keeping well and safe. Thank you to those who got in touch after the last podcast. It is always genuinely lovely to hear from people, so thank you. Anyway, continuing with the non-coronavirus theme. We've got three cases covering a range of subjects in this episode. We've got one, which is an important case in the Court of Appeal on disability discrimination and the correct test for that. We've a second case on the protection given to temporary agency workers, and we have a case where I'm going to confess up front, I'm not entirely sure what I think of it, but I'll explain it more when we get to that particular case. Please don't forget, as always, the podcast's available on iTunes, Mayor Brown website, YouTube, Twitter, Spotify, Google Play, Yahoo, all good news agents, etc., etc. Why don't we start with a case I don't know what I think about it? Let me explain. So, the case is AAA and BBB and versus CCC. So I'm going to call them A, B and C, obviously. And as I say, I'm not sure what I think of this case, although I'm troubled about where it may lead. Let me go through what we know from the case report itself and then try and articulate the concerns that I have and what may be the explanation for what is, on the face of it, a bit of an odd decision. And I realise, of course, that in any case in front of the Court of Appeal where both sides are represented by leading counsel, any commentator has to tread carefully. Part of the difficulty in this case, as you can tell from the title, is that it's been anonymised, and so I think there are areas where you can only glean from the report what may have been involved in the case. But, in brief, what we are talking about here is a final injunction preventing the defendant, C, from disclosing defined confidential information and information liable to identify A and B. C was also injuncted from making adverse or derogatory comments about them. It also this final injunction prevents C from seeking to damage the business of the claimants, A and B, or any other business controlled by B, by the release of confidential information or any other matter arising out of his engagement with A or B. Well, A is a company. B and C were equal shareholders in A. Allegations, according to the report, were made against C by an employee of A relating to sexual harassment. C denies the allegations and complains in turn that he has been sexually assaulted by the employee in question. This is also denied. But the allegations apparently led to a breakdown of the relationship between B and C. As a result, the parties, in August 2017, entered into two agreements resolving their disputes. Lawyers are involved on both sides. There's a settlement agreement between A, B and C, in which C transfers his shares in A to B. He gets paid £1 million in total for this, 800,000 of which was for the shares, and very crudely put, £200,000 was to ensure his silence. The second agreement was I assume, statutory compromise agreement that C entered into directly with A. Under the settlement agreement, the shares deal, there was a confidential information clause. Both parties agreed to keep confidential information secret and confidential at all times. In the settlement agreement, C's fiduciary duties to A were continued after the termination of employment, and C agreed that he would not seek to damage the business of A or B or any other company controlled by B by disclosing defined confidential information. The compromise agreement had a different definition of confidential information, really pretty broad brush, and covers information, for example, relating to business products, affairs, finances of any group company, any trade secrets, technical data, know-how, etc., etc. And in that document, C agreed not to use or disclose any confidential information to any person or organisation whatsoever. There was a separate clause under the compromise agreement not to make any adverse or derogatory comments about A, the company, any directors or employees or anything which may bring them into disrepute. As I say, C got £800,000 for his shares in A, but the balance of £200,000 was payable down the line, provided C complied with Clause 11, which was the confidential information clause, up until 31 January 2019. So 100,000 of that was conditional, or as I say, on complying with the confidential information clause, and 100,000 was conditional on the company retaining its contract with its major client until 31 January 2020. Surprise, surprise, neither of the balancing sums were paid because it was alleged that C had broken the conditions and that the major client had not remained with the company. It was alleged, and does not seem to have been significantly disputed from what I can tell in the judgment, that C had gone to the police and HMRC saying that A and B were involved in various instances of sexual misconduct, money laundering, forgery, bribery, tax fraud, racism and anti-Semitism. C also apparently threatened to disclose various of these matters to the press or on social media, and it is alleged threatened to make these allegations known to the major client. Now, from the report and the Court of Appeal judgment, I cannot be clear exactly which of these were effectively accepted by C, but certainly the accepted gist of it was that C had done some or all of these things. So A and B went for a final injunction to prevent C making these disclosures. C's defence was the allegations he was making were true, and the claim for injunction was intended to hide allegations of serious misconduct, some of which was criminal, and so it shouldn't be barred from disclosure. C said the injunction would amount to breach of Article 10, his right to freedom of expression under the European Convention of Human Rights. The claimants, A and B, by contrast, say the allegations are untrue, had been fabricated. It was also accepted that C had discovered these matters whilst he was employed, so the information which he was relying derived from his employment and presumably his directorship. Since this was an application for a final injunction, the judge was not being asked to determine whether or not C's allegations were true, and I think this is one of the points at which there's a sort of double take moment in the judgment. The case went to the judge and then up to the Court of Appeal on the basis that C's allegations were factually true. In other words, just to make the point, the judge was being asked to consider granting an injunction on the basis that C had correctly made allegations about material matters, some of which were criminal misconduct, and the company and the alleged, and I emphasise alleged of course, main perpetrator was seeking to shut him down with an injunction. Again, just to remind you, the allegations which are accepted for the purpose of this case as true: sexual misconduct, money laundering, forgery, bribery, tax fraud, racism and anti-Semitism. If you add incest and folk dancing, you'd have covered all the bases. Well, the claimant's case for an injunction was based fairly and squarely on the terms of the written agreements that C had entered into freely. C was acting for himself apparently right up until the final injunction hearing, and counsel got instructed very late in the day according to the court. But the reliance on Article 10 was rejected by the court, as were any other arguments, like the agreements had been procured through duress, or whether the agreements had been repudiated by A or B. As such, the judge granted the final injunction. The injunction said that C could not publish or disclose any confidential information which was expressly ordered to cover these allegations, or to make any, quote, adverse or derogatory, unquote, comments about A, directors or employees, or B, or seek to damage the business of A or B by the release of any confidential information, or any matter arising out of his employment directorships with A. As I say, the judge's order expressly apprised to prevent C from making disclosures of matters of the allegations of sexual assault, racism, anti-Semitism, sexually inappropriate behaviour, and reference to criminal behaviour by B. The judge's order was limited in two ways. First, the judge excluded disclosures to legal advisers for the purpose of obtaining legal advice, and disclosures under Part 4 of the Employment Rights Act, which would cover protected disclosures, whistleblowing. The Court of Appeal granted leave to appeal only on two bases, which were that the contractual provisions did not justify the relief granted, and that the orders were insufficiently clear. As a result, a lot of the Court of Appeal decision is taken up with technical matters on the wording of the order. Is it too vague? Are the terms on which it is based too vague to support the injunction? For example, criticism is made of the very wide definition of confidential information. The judge had decided that the terms were sufficiently clear, not least because they had to be seen in the overall context of the fact that the claimant was being paid £1 million. And the judge thought this was equivalent to a trader agreeing to a worldwide non-competition provision on selling the goodwill of his business. The judge also decided it was possible to give the clauses meaning in the context of particular actions, and that they employed non-technical language to deal effectively with concepts that were understood. The judge also accepted it could be adverse to disclose the truth about someone, and took the view that it could be derogatory, adverse or harmful, and bring a person into disrepute if matters are disclosed which are true but which are not otherwise in the public domain. Pause there. On that basis, the fact the allegations were true was not a defence to C being in breach of the terms of the two agreements he had entered into, according to the judge. Basically, the Court of Appeal agreed and said the judge should be entitled to make the order that he had, with a couple of minor tweaks and twiddles. As I said a minute or two ago, much of the Court of Appeal decision is taken up with the wording of the order and the particular clauses. And certainly I, as the reader of the judgment, I'm left on the outside going, but, like some sort of cartoon character, given that we have a gagging injunction to prevent someone making statements in public which are assumed to be true about criminal behaviour and material misconduct. Now, let's work from the other angle. Let's assume the case is completely logical and sensible, and well, how do we get there, and why would my reaction be wrong? Well, part of the explanation for the decision may be the way in which the case went up to the Court of Appeal and the points that were an issue in front of the court. As I say, C had apparently represented himself until very late in the day prior to the hearing for the final injunction. Much of this case may therefore depend on the way that C had argued his own case initially, and the extent to which issues had been identified in the running up to the final trial. Secondly, leave was restricted by the Court of Appeal to the specific wording of the order and whether or not it was too vague and the underlying terms too vague. We don't have any details of why Article 10 was rejected by the judge, or indeed why the Court of Appeal rejected any attempt to appeal against the Article 10 finding. The other point to bear in mind is a lot of the cases to do with anonymity of parties and keeping things away from the public gaze involve the newspapers as a party to the litigation, and they are formidable exponents of the right to freedom of speech. They weren't involved here. Although clearly C had been threatening to go to the press, so I wonder what the newspapers would have said about the ability of the court to restrict the publication of stories which were true and involved material and potential criminal wrongdoing, according to the assumptions that had to be made by the judge. It's obviously important to note that whistleblowing was excluded from the ambit of the order, but as I thought had been made clear by commentators when talking about gagging clauses post-Weinstein, part of the problem with simply restricting the ability to disclose matters to permitting lawful protected disclosures is the fundamental uncertainty of knowing what is or is not a protected disclosure. Here C is apparently being asked to take the risk of a contempt of court finding if he misjudges his legal right to make a protected disclosure to a particular person. That by itself ought to give pause for thought. Surely it's no answer to say that a judge might not view it as a matter of contempt if C made an honest mistake and thought he was making a lawful protected disclosure. The threat of the committal is the gag in itself. Against all of this is the considerable feeling of unease that an employee who was aware of what we assume to be true acts of misconduct, assuming in the context of litigation at least, true acts of misconduct committed by his employer and shareholders, has been gagged. An injunction now exists preventing him from making any adverse or derogatory comments about an individual. Similarly, at the end of the day, of course, we don't know what impression C made on the original judge, but it does also seem to have played heavily on the judge's mind that C was paid a large sum of money, and as such, according to the judge, this situation was analogous to a shareholder giving up a share in a business in return for a large payment and a worldwide restrictive covenant. But even there, I'm not sure of the analogy. There is surely a world of difference between I'm selling you my business, and in order to procure the transfer of goodwill, I commit to a long covenant, with I know you're guilty of criminal misbehaviour and I accept a large sum of money to keep my mouth shut, and then you can injunct me if I threaten to disclose anything. They're not really alike, are they? The other point, and look, this may have been canvassed below, but it wasn't the subject of appeal as far as I can see, is the idea that an equitable and discretionary remedy, an injunction, is granted without an apparent discussion about whether it is equitable to gag the employee in these circumstances. Who knows, maybe after all there is confidence in iniquity. The final point to note is the Court of Appeal appeared to have assumed, without it being argued, that if C had contended that the agreements were unenforceable, that would have meant that C had to repay the money he received for his shares. Well, if C was not arguing the point, then presumably C, on advice, agreed with that. That would presumably also have meant the return of the shares back to C from B, if possible. I wonder in an employment situation where there's a transfer of shares not involved, whether this point might be of less concern. So it's going to be interesting to see whether this case is going to be used by other employers keen to gag employees. How this fits around the SRA guidance on not using gagging clauses in settlements. And of course the SRA exceptions to gagging go rather wider than simply permitting legitimate whistleblowing disclosures. I started off saying that I was approaching this case with caution, given I didn't want to rush in where angels fear to tread. That said, certainly I think employers should view this case with caution before they rush to obtain injunctions seeking to prevent the disclosure of adverse or derogatory comments, even if they are true. And advisors had better be very clear about their professional obligations before trying to gag employees and ex-employees in settlement documents from making disclosures of material wrongdoing beyond lawful protected disclosures. So that's the case of AAA, BBB and CCC. Next up, Robinson and Department for Work and Pensions. And I'm sure you're going to be pleased to hear that we can deal with the next two cases rather more succinctly. This case is a case on disability discrimination and the test that should be applied in deciding whether or not an employer has been guilty of unlawful discrimination. It follows in the footsteps of a case decided last year, and I think it's useful to be reminded of the appropriate test, especially as it can avoid both the parties and the tribunal falling into error otherwise. It's probably easy to start with the facts and then go on to the applicable law. The case concerned an admin officer at the DWP. Having worked there for 20 years or so, she developed a migraine condition which caused blurred vision in her left eye, which affected her ability to undertake certain day-to-day activities. It was impossible for her to work on her computer using the system that was applicable for the DWP. Further changes introduced by the DWP at around the same time made life worse for her rather than better. There's been a prolonged period where the DWP tried a number of technical solutions to see if they could adjust the screen magnification software to accommodate her needs. During this time, the claimant was under particular stress, and ultimately in 2016 she brought a grievance and, by agreement, moved to a paper-based role on a temporary basis. The grievance was eventually upheld by the DWP. It was said that the failures by and large were mistakes and or process failures rather than an individual behaving in an inappropriate or negligent manner. Inevitably, the claimant filed a disability discrimination claim, claiming both under Section 15 of the Equality Act and Section 20. Section 15, of course, discrimination arising from disability. Section 20 is the failure to make reasonable adjustments. And the claimant's case was based on 4 instances of unfavourable treatment. Her removal from the Debt Management Department, failure to deal with her grievances in a full and timely manner, failure to implement reasonable adjustments that were recommended, and failure to provide work suitable for her skills capability and to allow for future development. The Employment Tribunal upheld her claim, saying there had been discrimination contrary to Section 15, disability arising, but there had been no failure to make reasonable adjustments contrary to Section 20. This apparently contradictory approach led the respondents to appeal to the Employment Appeal Tribunal, which upheld their appeal in full, and went further. It dismissed the case of the claimant without referring it back to the Employment Tribunal on the basis that the findings of fact precluded a finding in favour of Section 15. Claimant appealed to the Court of Appeal, and much of this case, to be honest, is taken up with a review of the circumstances in which the AT can decide a case itself on appeal or send it back to the Employment Tribunal. But I want to focus on the other aspect of the case, which is the fundamental test under Section 15 of the Equality Act for establishing discrimination arising from disability. The employer here relied on a case called Dunn and Secretary of State for Justice, which was decided late in 2018, which is also a Court of Appeal decision on the appropriate interpretation of Section 15. In Mr. Dunn's case, the Employment Tribunal had found the employer had failed to react appropriately to occupational health report recommendations. It had failed to put support mechanisms in place to enable his return to work, and his early retirement application had been mishandled. However, in the Dunn case, both the AT and the Court of Appeal had decided that the statutory test under Section 15 required the Employment Tribunal to consider the question of whether the unfavourable treatment was because of something arising in consequence of disability. It had to be more than a trivial reason, but it was not sufficient for the court to find that, but for the individual's disability, the adverse actions would have happened. The individual's disability needed to be a significant or more than trivial reason for the adverse consequences happening. Therefore, in the Dunn case, to take one example, the fact the ill health early retirement process was very poorly managed in respect to Mr. Dunn did not lead to a finding of disability arising discrimination because it was due to incompetence. It had nothing to do with the fact of his illness. Returning to the present case, the Court of Appeal was very clear that Section 15 requires the Employment Tribunal to ascertain whether the treatment was because of the protected characteristic, and as such, that would require a tribunal to look at the thought processes of the decision makers concerned. It was not a case of having to say that there needed to be an adverse motive. It did, however, require a link to be found that because of the disability, the adverse consequences occurred. As with the Court of Appeal in the Dunn case, a prima facie case is not established solely by the claimant showing that she would not be in the situation of being the victim of delay and incompetence if she was not disabled. On that basis, being removed from the department, for example, was not evidence of discrimination contrary to Section 15 because it was reasonable and proportionate to move her to a paper-based role. Similarly, failing to deal with her grievances in a timely manner was not the same as establishing that the managers delayed the resolution of the grievance because of her disability or the symptoms arising from it. So, standing back, my reason for including the case was that I think it's very easy for tribunals and the parties to get caught up in whether there's been adverse action and whether the employer can show the adverse action is a proportionate means of achieving a legitimate aim. It's also necessary, however, to look in all but the most blatant cases at the thought processes of the decision makers to see whether the fact of the individual's disability was a factor that they consciously or unconsciously took into account in deciding on the alleged detrimental action or omission. To that extent, I think the case is a welcome restatement of the position in Dunn. So, Robinson and Department for Work and Pensions. Final case, Angard Staffing Solutions Limited and Royal Mail Group Limited and others. This too is, just like the last case in fact, a restatement of the law rather than a brand new point. It relates to the temporary workers provisions under the Agency Workers Regulations 2010. Broadly speaking, the Agency Workers Regulations, of course, provide for equality of treatment in certain specified areas for people who are relevant agency workers as compared with permanent staff. Under the 2010 regulations, a relevant agency worker means someone who is supplied by a temporary work agency to work temporarily for and under the supervision and direction of a hirer, and who has a contract with the temporary work agency, which is either a contract of employment or a contract with the agency to perform work or services personally. The definition of temporary work agency matches that and effectively applies to the business of, quote, supplying individuals to work temporarily for and under the supervision and direction of hirers. Unquote. The case concerned temporary working arrangements at the Leeds Mail Centre for the Royal Mail. Angard Staffing Solutions is a wholly owned subsidiary of the Royal Mail, handling the supply of labour to the Royal Mail. Permanent employees are employed directly elsewhere by the Royal Mail, but Angard provide the flexible resource for working at the Royal Mail throughout the country, where permanent staff are unable to undertake the work. Angard does not provide employees to any other organisation. Mr. Coker, the claimant, was retained by Angard under an employment contract which was open-ended, but he was effectively supplied by Angard to the Royal Mail Associated Company on a series of shifts. The claimant, of course, wished to claim he was a temporary agency worker, presumably to claim equality with the Royal Mail permanent staff, and the Royal Mail, equally unsurprisingly, was determined that this was not going to happen, hence the court case. Well, the Employment Tribunal found that the individual was a temporary worker. It rejected the idea that the individual's employment was open-ended, i.e. not temporary, just because he had an open-ended contract of employment with Angard. The Employment Tribunal pointed out the focus needed to be on the work which the individual was undertaking for the Royal Mail, which was a series of shifts, rather than looking at the arrangements he had with Angard itself, which was making his labour available. As the tribunal judge put it, it's not the contract of employment with the agency which must be temporary for the purposes of the agency directive and regulations, but the work which was undertaken for the hirer. Here, in the lead case, and there were other cases alongside Mr. Coker's work for the Royal Mail was always time-limited. Ascribing time limits throughout the periods of work for which he provided cover was fatal to the argument that his engagement by the Royal Mail was not temporary. The case goes up to the AT. The AT took the view that the individual claiming to be a temporary agency worker had to meet two conditions. First, there had to be a particular type of contract between the alleged temporary worker and the agency. There was no dispute about that here. Secondly, the tribunal needed to decide, in the particular case, whether the worker was supplied to work temporarily for and under the supervision and direction of a hirer. That, in turn, requires the tribunal to make findings about the basis on which the worker is supplied to the hirer and whether that amounts to a temporary supply. The wording of the temporary worker regs looks to the basis on which the worker is actually placed or directed or sent to the hirer on one or more occasions. The tribunal, the AT said, should ascertain whether the supply is made on the basis that, having embarked on the assignment, the worker will continue to work for the hirer indefinitely, or whether it is on a series of fixed periods which will be completed at the end of the time period or the completion of the task. The EAT agreed with the tribunal that it is not looking at whether the overarching relationship with the agency and the worker is temporary or permanent. That could, and indeed here it was present, it was open-ended. Here, the contract which Mr. Coker entered into with Angard envisaged, however, that he would be provided on a temporary basis to the Royal Mail, i.e. particular shifts, and that's exactly what happened. On each occasion he was supplied, his work was time limited, and as such, the temporary status was not affected by the number of such assignments he had done over a 4-year period. Tribunal also found, and the EAT commented that it was right to do so, that merely because the agency, in this case Angard, is only providing individuals to one customer, the Royal Mail, with which is an associated company, this did not take it outside the scope of the directive or the regulations. So the upshot of this is that Mr. Coker and the others are found to be temporary workers, notwithstanding the fact they have been working long-term for the Royal Mail as a matter of practice. As the Employment Tribunal put it, it is the fact that each such posting is time-limited that makes them temporary rather than permanent. Given the obvious insecurities in having a series of temporary time-limited postings, it's hard to disagree with the conclusions of the Tribunal or the EAT in this case. So employers who make regular use of flexible labour are going to need to be aware that the agency regulations will apply to staff even if they are in practice retained over many years, or they have many projects or many time-limited pieces of work back to back. You only really get away from this if the individuals are permanent and their engagement is open-ended. Of course, that's precisely what employers are looking to avoid, and why protection in turn is needed for agency staff. So that's Angard Staffing Solutions Limited and Royal Mail Group Limited and others. So there we are, thank you. That concludes podcast 184. I hope you find this useful. I'm happy to confirm that no air corridors from Spain were used in the making of this episode, and therefore you do not need to self-quarantine after listening to this podcast. Thanks very much, everyone, and stay safe. Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.